Welcome to Estate Planning Beyond the Binder.
Welcome to Estate Planning Beyond the Binder, where we break down what you really need to know to protect the people you love and the life you've built, and how the estate planning firm you hire helps to make sure your estate plan is actually effective. I'm your host, Zofia Morales, and our expert is Brian Chu, estate planning attorney, dad, and founder of OC Wills and Trust Attorneys. So whether you're a married couple with kids, a homeowner, a business owner, or just starting to think about your future, this show is here to make your estate planning simple, doable, and built around what matters to you. Today's episode is Estate Planning 101, the binder and child protection planning. Welcome, Brian. I'm so happy to have you here with us today.
Well, thank you so much, Sophia. I'm excited to be here.
Yeah, so let's start with the fundamentals. What is the binder, and how does it help busy families stay organized and protected?
Most people, when they think about estate planning, they think about this binder of documents. That typically it's something like this. You have something like that. That's what most people think of when they do an estate plan. They're going to get some binder of documents. Okay. And that's what we call an estate plan. And this is the beginning of making sure your family's protected if something happens to you.
I love that you said that it's the beginning of making sure your family's protected. There are a few things you have to do besides getting that binder, right, to make sure that your plans get executed.
Yes. I mean, that's why, I titled this podcast, Estate Planning Beyond the Binder, because too often people focus on just getting this binder of documents and they get handed the binder and think, great, I'm done. And, and yes, you need the binder, because if you don't have the binder, you don't have a plan.
Right.
Okay? I mean, that's like step one. But they don't realize that there's more that has to be done beyond the binder. And it's a work that happens after we sign everything with our clients, that we help them. The clients are responsible. And then when they have questions, they have needs, we're there to support them. Okay.
Exactly.
And we find those things are really just as important. Well, maybe not quite as important, but very important to make sure you have an effective estate planning. And that's really what our focus is for our clients, is making sure not only you have a plan, but you have an effective estate plan.
So how is it that estate planning is more than just having a will? I know in my naive moments before I entered into the world of estate planning, I thought, if I have a will, I'm good to go.
So a will, for some people, a will might be enough. Okay. A will says if I pass on, somebody's in charge and this is where I want things to go. The problem is here, especially in California, for most of us, if we just have a will, it's going to be subject to what's called probate. Okay. Our assets will be subject to probate because we own something like a home, or we have minor children. And in either case, if our assets go to probate, which is a court proceeding, it's going to cost our family tens of thousands of dollars in legal fees. And so most of my clients, they come to us because they want to avoid that situation. They don't want the courts involved. They don't want the government and judges involved. They just want to handle things privately. Obviously, when you do things privately, you might involve an attorney, but it's going to be far cheaper, much faster when we don't involve the courts. And so that's why generally in my practice, we're doing 99% revocable trust instead of wills.
Okay. So when you sit down with someone like yourself and you create a binder, how does this binder ensure that your spouse and your kids are cared for if something happens to you?
The basics is, if you have a plan, at the very least, if you are setting up a set of documents that gives somebody the authority to act when you can't, okay? Either to be in charge of you from a medical standpoint, your assets, and for those of us like myself who have minor children, most importantly, our kids, okay? Because without any documents, nobody's in charge. If something happens to you, if you're incapacitated or passed on, and we always want to make sure somebody's in charge.
Yeah, and somebody that you chose to be in charge, not some random person at Child Protective Services.
Correct. Yeah, we want to be able to choose. And even, people, even other people that we do love, that, we might trust, might be multiple people. We don't want them fighting, okay?
Right.
We want to make a choice so that we tell them, okay, this is who we want to be in charge. And if that person wants to be in charge, they have the authority to be in charge without having to go to court, and hopefully avoid anybody arguing about things.
Right.
Okay, because it's already bad enough something tragically presumably has happened. Now we just want to avoid both, obviously it might be two sides of a family fighting to figure out who should be in charge.
Right, and creating more trauma in an already traumatic situation.
Exactly. And so that's the point of having a plan, is you get to have your voice as far as who you want to be in charge or you can't be. Because otherwise, if you don't do anything, there is no voice. They'll figure it out, which is going to be not only expensive, but who knows what the legal fight's going to look like if there is one.
Right. And what the outcome is going to look like. It may be radically different than what you in your heart thought would maybe play out.
Of course, yeah. You want to have your choice. You want your wishes known, and assuming that person wants to do it, then they will presumably be able to take over with little incident.
So when you're creating something like this and you're looking at like a child protection plan, what all is under that umbrella of the child protection plan, and why is it critical for parents of young children?
So, when we have, like I said, we have minor children, obviously they're very vulnerable if, something happened to my wife and I, or if you're worse, if you're a single parent, obviously there's only one of you potentially, is who's in charge of my kids when I can't be. Okay, it's one thing to be in charge of money. They'll figure that out. I mean, worst case, it's going to cost money. Okay.
Yeah.
But I'm concerned as a parent, who would take custody of my children? Okay, both short term and long term. We, especially out here in Orange County, we have a lot of clients whose potential guardian, somebody they'd want to take over if they weren't there, they're not even in this country. Okay, let alone close by. And so the first part of the kids protection planning is who's taking care of our kids today. Day one, wife and I, we go out to dinner, we're in a car accident, something happens to us, who's taking care of the kids today? Okay.
Yeah.
We don't want to end up with child protective, obviously the police are going to get involved. We don't want them to end up in child protective services, or worse yet, in foster care. It's already tragic enough. Something's happened. We're not here. We want them to be with somebody, at least maybe they know.
Yeah,
Okay.
exactly. A neighbor or
Yeah, and that may or may not be, a relative. It may be a friend. It may be, we want to, and so some of the docs we do for our clients with minor children is we create a document that gives somebody temporary authority to take care of our kids and or make medical decisions for them. Okay.
Right.
Now that might actually be the long-term guardian, because if they happen to live nearby, then that's what makes sense to put them. But again, for those of us, my clients who don't have anybody that's nearby, it's really important they have documents to give somebody temporary authority so that they could show the police, hey, I have some level of authority. And while the police aren't required to accept that document, it's better than nothing.
Yeah, it at least shows what your intentions were.
Correct. And so that's beyond even what we do long term, which is in the will, is one of the other docs we do for somebody. We nominate backup guardians for a judge who we want to be the long term guardian, but that's a court proceeding. So that doesn't happen right away. So who's taking care of the kids until an actual guardian's appointed? Because again, that's a whole legal proceeding that doesn't happen right away. And so we want to make sure somebody has temporary authority. And then obviously that's a short term. And then long term, in your will, you're going to nominate backup guardian. And assuming that person wants to do it and they apply to a judge, petition a court that they want to be the guardian, and if they're on your list, most likely they'll be approved. Okay. But I always tell my clients, you can nominate anybody you want. Okay.
Yeah.
But but no one's going to go looking for these people. These people, whoever it is, they have to go to court and say, I want to do it. Okay. And that's true for all these documents. We're going to nominate, appoint people, but again, we're assuming they're going to do it. So obviously that's part of the conversation you're going to have with whoever it is.
Yeah, I was going to say that's one of these beyond the binder sorts of things, right? You may have nominated someone, but it might be good to have a little conversation with them
on
before the day arrives. Yeah.
Obviously the kids are number one thing. I mean, there's the whole logistics. We talk a lot about the logistics of what needs to happen when somebody passes, because you're not going to be there to tell them the logistics.
Right.
And then when we have kids, it's anything about the kids. Is there any allergies, medical conditions, anything they should be really aware if they need to take care of the kids, to make sure they can take care of that. And that's obviously issue number one for those of us with minor kids. And then even if you don't have minor kids, where's all the money? Okay. Yeah. What bills to pay? But the biggest is where's all the money? Because if I pass on, there is no list. I mean, that somebody just magically, I have to create the list.
That's right. That doesn't materialize.
And especially nowadays, back in the old days, we would just wait for the mail to come. The statements will show up eventually and we'd see it. Nobody's getting mail anymore. Those statements don't show up in the mailbox. Maybe they have access to your email, but that's assuming they can get it to your phone, and that's a whole different issue. So there's all these logistical issues that we talk about as part of our planning process to make sure that you do everything you need to do to make sure it may even be your spouse. A lot of times we have one spouse who's taking care of things, all the financial, and the other one has no idea. Okay?
Yeah, exactly.
Each other, they got to know everything, and likewise, there's could be things about the kids that the other spouse doesn't know, and so that's the logistics of again, the binder. I always tell people my job is to get somebody to your desk. Okay, they're at your desk, they're in charge. Okay. Now the question is, now what? Okay, because even if they come to someone like myself, I might have created the plan, but I have no idea. I can tell you generically what to do. Go get the money. Well, I have no idea where the money's at. I don't get involved in that. We don't know where any of the money's at. You've got to tell them. We don't know anything about your kids. Okay, you've got to tell them. We don't know anything about your bills. Okay, you got to tell them. You go over mechanisms of how people can provide that information in a safe way for whoever might take over when they couldn't be in charge.
So, going back to the kids for a minute, what happens if you put this off and something terrible happens and you haven't gotten around to nominating anyone to be guardians for your children? How does that play out?
It is a court proceeding, and presuming somebody will step up and say, I want to be the guardian. Obviously, worst case, nobody does it, in which case, yes, they're going to end up in foster care, essentially, with child protective services in the foster care system, which nobody wants. But it is a court proceeding that somebody initiates. Okay, and obviously, if you have no documents, anybody can initiate it, and then the judge will, there'll be a proceeding where they'll have to notify the closest relatives, say, hey, do you want to do it? If you want to do it, this is the time to raise your hand. Okay, but the judge can only choose amongst the people that raise their hand. So even if I do have a plan, if the people that I nominate don't volunteer to do this, well, the judge can't choose them.
Oh,
okay.
Ooh,
So the judge,
bit of information we may not have known.
The judge can only choose amongst the people that apply. And so I want to have a voice. So it's important I have a voice, but just as importantly, that I would know that I've talked to those people and that they will do it. So again, something outside the binder that can only do so much. That's a conversation you want to make sure you have with whoever you are nominating first, that they would actually do it. Now, at the end of the day, they can agree all they want today. If the time comes, they're going to have to step up and want to do it. And then the judge will choose amongst who, will choose based on the information they have. And obviously, if you have something like a will that nominates a backup guardian, that's where you're going to, they'll obviously take what you say under great advisement that has a great weight. Obviously, at some point, your kids also have some say, especially as they get older.
Just to give us kind of an idea, a ballpark, what is kind of the time frame on this court activity if there hasn't been someone nominated?
Months. I mean, and that's assuming, depends. I mean, just to get, the proceeding, and then you have to give notifications because you got to give everybody adequate time to say, figure out where they want to do it and then file their paperwork. And then there's, presumably hearings. Then people plead their case as far as why they, obviously it's going to be much faster, much simpler when only one person applies or a couple apply. Okay. But obviously you can be dragged out if multiple people apply. And again, by having your nominations, you're hoping to say, okay, I've nominated you first, and if that person applies, hopefully no one will challenge them because they know in all likelihood they'll lose.
The end of it. Yeah.
That's the goal. We're trying to, we don't want a legal fight because that's where it's going to A, get expensive for everybody, and B, well, again, that's the last thing we want anything to happen is people arguing about what the situation is.
And the kids being in limbo for months and months on end.
Correct. Yeah. No, the good news, I'll be honest, it hasn't happened for any of my clients yet. So I hope that will never be the case.
That's why they're your clients.
But you want the plan. You want the planning because you never know. I always tell people the most dangerous thing we do every day is get in a car. Especially out here in California, we're all in a car. And I always, the disaster plan that I envision is always involves the car. Who's in the car? What could happen? And that's where all the comprehensiveness comes from the planning is, well, if all these people are in the car, if something happens to all of them, what happens next? So that's the type of planning we're trying to do comprehensive planning that anticipates births and deaths. The only thing I can't anticipate is political changes, family politics changing. Births and deaths I can anticipate. So we usually make sure our plans contemplate both.
Yeah. And I think that's where my father's plan actually came up. They anticipated that they would live great until they keeled over, but that in his case, he ended up incapacitated for a number of years before he actually died. And that's where his plan, I think, came up short, was that we hadn't considered the incapacity possibility.
And that's just an important part of the planning in the sense, especially in the sense of when I tell people, okay, you're going to choose somebody to be in charge. Okay. You're not only just choosing that person to be in charge while you're alive. If you pass, you're choosing them to be in charge of you, of your assets. If you're alive and incapacitated, you've got to make sure you're comfortable with whoever that person is. Because some people, they're comfortable, maybe this, if I'm not here to take care of the kids, take care of the money, that's fine. But yeah, the incapacity is also part of the, the considerations as far as, and in fact, for a lot of my clients, especially those that don't have kids, I said the number one consideration for me is who is in charge if you're incapacitated. Okay?
Yeah, absolutely.
I almost care more about that, or at least I care about that for my clients more about that than even where the money goes, because, well, you're not here anymore.
Yeah, you're not really going to care one way or the other.
You probably care a little bit, but again, it's not your kids at that point, so it's a little different.
Yeah, exactly. So how does good estate planning help your family to better navigate the chaos and avoid court situations when there is something terrible that happens?
I mean, the number one, somebody's in charge. Okay. They have authority to take over by filing paperwork. Okay. Because that's the difference between a trust and a will. A will does the same things. You pass, somebody's in charge, what they call the executor. All right. However, they can only become in charge of assets if they go to court. And in order to go to court, which is probate, they have to hire an attorney, and the attorney's going to charge them tens of thousands of dollars in legal fees to represent them.
Right.
Okay? We want to avoid that. And so by having a trust, somebody can take over and they just need to file paperwork. Usually it's a death certificate and a copy of the trust that says I'm in charge, and the bank, the life insurance company, the Orange County recorder, in my case, the local county recorder, the bank, whoever it is, you show me that paperwork. If the trust was made the owner or beneficiary of that asset, we'll accept whoever can show me they're the trustee of the trust. You have authority. Okay, that's how you avoid the chaos of having to go to court, is because somebody is in charge. The trust is like a company. I always tell people, if the president of Google dies, Google doesn't go to court and get a new president. They just appoint a new one. And the president had the ability, before had the ability to write checks and sell stuff. Same thing. Something happens to you, the new new president that's appointed through the Google documents, now they have the ability to write checks and sell stuff. That's exactly what your trust is. It's like a company. This company while you're alive, it is you. But once you pass, it outlives you. It continues on as a separate entity, and it's just who's in charge of this entity. And that's what we call a successor trustee. If you're incapacitated or passed on, that person can take over by just showing paperwork. That's the goal, because as soon as you have to start going to court and to get things done, that's where things get very expensive. And the other thing is, I'm sure we'll talk about this in a future episode, having the trust by itself does not guarantee we avoid this outcome. There's a lot of steps that have to go into place once we create the trust. You sign the trust, that has to happen to make sure we don't get the courts involved. Because plenty of people have trusts. I just had somebody walk in the other day. They've had a trust for 25 years. They've owned a home for 21. The house is not in the trust.
Oh, right? No.
Fortunately, they've come, so we can fix it. But
yeah,
they went 21 years where if they had passed, the house would have gone to probate, what we were trying to avoid in the first place. So they had a trust, but the house, for whatever reason, was not in the trust. Okay, and I talk about what we do with them moving forward to help make sure that doesn't happen again.
Yeah, because it's really easy to open a new account, or you have a new child that enters the family or something, and this hasn't been addressed in any of your planning documents.
Yes, I mean that's why we try to work with our clients to make sure your estate plan's not out of sight, out of mind for too long. Because that's what happens with people. That's why I'm saying it's beyond the binder, because they got the binder on the shelf and they think, okay, I'm covered. But as things change, things may need to be changed, and it may not even be the trust itself needs to be updated. It's the assets. Most likely, it's the assets that need to be updated. And we're not even necessarily not even technically have to be involved. Just something needs to be done. We're there to support our clients and helping them get those things done. But, it may not involve us having to do something. It's just doing something I told them what to do. And we'll be there to support them to make sure that, when they do, if they do need to get it done and they need help, we can help.
Exactly. And that it does get across that finish line.
I would say planning, estate planning, it's process, not a product. It's an ongoing process. And as things change, you need to be changing either the plan and or the assets to accommodate the changes.
Yeah. So what do you have to say to couples who've been putting this off for whatever reason? We don't have enough stuff or whatever time, money. There are all kinds of reasons that we put this sort of thing off. What's the first step that you should take, the first baby step towards getting a plan in place and having your affairs organized?
First, I think it's having your affairs organized. I've just asked this question earlier today. What if I had to tell somebody what's the first step you should do when you get home tonight? First step is organize things. Okay, where's all the money? What bills to pay? If you have kids, anything about the kids, and then make sure that you have an emergency contact list on your person, in your car, on your refrigerator, in your kid's backpack, at work, so that if something did happen to you, someone would know who to talk to. Because that's issue number one, the logistics. That's not a legal issue, that's a logistical issue. And especially I have a lot of clients, they have nobody nearby. So that's near one, is the logistics. You got to organize it. Step two is, contact someone like myself, an estate planning attorney, so that we can help create an effective estate plan for you. And as I tell people, people a lot of times they put it off because they're afraid of having to make a lot of decisions. Yes, you need to make some decisions about who do you, I always tell people, the answers I need is who do you love, who do you trust, and how much do you trust them? Okay. Especially depending on the third question, those are the questions I need answered to do 89% of your estate plan are those. I don't need to know a lot about the assets. I don't need where you want your antique tea set to go. I don't need to know any of that stuff. Okay. I need the answers to those 3 questions. That'll tell me the bulk of what I need to know to get your estate plan set up. Okay. I want to know, I need to know your goals and concerns.
Yeah,
and then we can have a conversation.
And I think those are manageable questions to answer, I think, for most people. Who do you love? Who do you trust? And how much do you trust them?
Yeah. I mean, the trust is kind of the loaded question sometimes, and even between spouses and, sometimes, but I always tell people, I had a client just today where she keeps pushing back signing the document because she keeps worrying about, well, what might happen 3 people down the road if this person's not alive, this person's alive, this not alive, what might happen, and she's getting stuck on that. And I'm saying, okay, at the end of the day, I want to do what you want to do, but don't get stuck on things that are probably not going to happen. Be concerned about the stuff that the thing you get in a car accident tomorrow that is going to happen if that happens, and let's make sure we got that covered, because if you don't do anything in this particular instance, things are not going to go the way you want them to go. So you got to get something in place. Something's better than nothing.
Amen.
And you can change it. Almost virtually everything I do is revocable and changeable. Okay. Yes, there might be some costs associated with changing things depending on the circumstances, but it's better to have something in place. Okay. And again, as things change, I always tell people most of our planning is pretty comprehensive in the sense of I can anticipate births and deaths. I'll do planning for married couples, young married couples who are planning on having kids in the foreseeable future, but don't have them yet, or are going to have them. They haven't been born yet. I said, that's fine. We'll draft the trust as if you had kids, and you don't need to update the trust because you have them. I'm going to accommodate whether you have 1 kid or 10 kids. Assuming you're treating them equally, we can accommodate that in the trust, and you don't have to update the trust. And then also we're going to have it work the other way. If people that you do put in the documents pass away, whether it be somebody in charge or not, we're going to have plans A, B, and C typically. So we're covered again. So you don't necessarily even have to update the documents if those things happen.
I love it. Yeah, that's some great information right there. Just to get started on the right foot. I love that. Thank you so much for joining us today and providing the insight and the motivation, I will say,
all right,
to get our affairs in order.
Well, thank you, Sophia. I enjoyed talking to you.
Thanks for tuning into Estate Planning Beyond the Binder. If today's episode sparked questions, or if you're ready to create a plan that actually works when your family needs it most, visit ocwillsandtrust.com to learn more or schedule a consultation. Don't wait for the crisis. Let's plan with purpose together. And make sure to like, subscribe, and review so other people can find this information as well.
Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.